Viva! 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 Viva!
So I think a cash bill of 20,000 is sufficient with one contact person. Matter will be mentioned on the 16th of August for discharge of these orders. Thank you. Applicant Inspector George Karanja is what we are dealing with this afternoon. I have mentioned something concerning the fact that the court is fully cognizant of what has been transpiring in this country in the last 6 weeks, and also the fact that this court is also fully aware and empathizes with the hazards that the law enforcement officers have to endure under such difficult circumstances to ensure that law and order prevails and ensure that lawbreakers are brought to book, and that it has always been this court's position to only grant such a pre-charge detention order where there is no objection that has been raised by the respondents. And whenever the objection is raised against granting of such an order, then the onus and burden shifts to the applicant to demonstrate that they have met the criteria of granting the orders. The relevance of the doctrine of stare decisis has been also touched on in this application. I think Mr. and the Superior Court's decisions in the case of Michael Rotich, 2016 EKLR, Betty Jemtai Kimaiwa, 2018 EKLR, Oscar Kipchumba Sudi, 2020 EKLR, and the Court of Appeal decision of Michael Juma Oyamo, 2019 EKLR, are of relevance to this case, and the relevant passages in those mentioned authorities have been cited briefly in this ruling. So the onus therefore remains on the police to demonstrate why the 5 respondents. Did I communicate with you? Or is it that you're trying to be smart with me? So the onus is on the police to demonstrate why the 5 respondents in this case should be denied their constitutional rights to bond, and they must give compelling reasons applicable to an individual suspect and not a blanket reason, because the constitutional right to bail is an individual right as a human right, and blanket statements cannot apply. I have looked at the application and the response by the counsels on record. The applicant has not demonstrated why the respondent should remain in custody while he concludes his investigation. Specifically, what part of the investigations would necessitate the respondents to remain in custody or how the suspects are likely to interfere with the investigations, and just to reiterate that under the Constitution, all offences are bailable. There are 2 crimes that the applicant is investigating which can be classified as misdemeanors, and so the seriousness of the offence being investigated is a relevant issue. All offences being bailable under our Constitution, then more so misdemeanors. So it has not been disclosed what he intends to do with the respondents for 21 days, or how, the complexity of the investigations that necessitate the number of days that he has sought. And I think he needs to avail himself to the guidance of the Superior Court in the case of Michael Rotich,